Hello, everyone. Greetings from Ambition Law Institute. We have all heard about trials being conducted in courts of law, and we also know that it is not always possible to gather perfect evidence for a perfect conviction or acquittal. And sometimes the witnesses that are acquainted with the facts and circumstances of the case are children, children of tender years of age. They are susceptible to tutoring. Their evidence might be tampered with. The testimony that they give in court might not be very reliable. Therefore, we follow the Voire test. This test is followed by the courts to see and ascertain the maturity and competency of the witness. Oaths to say the truth, to see whether the witness is telling the truth or not. What is the maturity of the witness? What is the capability of the witness? And then we ascertain the brevity of evidence in his testimony. When a child comes into a court of law to give his testimony, the court asks, "What is your name? What is your father's name? Where do you live? Which school do you study in? Which color clothes are you wearing?" These are not related to the case, but the court is trying to ascertain the maturity of the child, to see whether the child is capable of giving reliable evidence in court or not. If you see section 118 of the Indian Evidence Act, any person who is competent to understand the question and give a reasonable answer can be a witness and can testify. Any person who is able to understand the question and give a reasonable answer, that person will be competent to testify, and a child will also be competent to testify. But the voir dire test is a check on the admissibility of such testimony so that the interests of justice are not hampered with. The child might be telling everything which is reliable. The testimony of the child might be absolutely reliable in a court of law. It might be very relevant also to the case. But the justice system has its own duties to follow. And the Supreme Court in H.S. Vahurwag versus the state of Maharashtra has very categorically said that if there is failure to conduct this test, but still, in the opinion of the court, the testimony of the child is reliable, relating to the facts and circumstances of the case, then such testimony given by a child witness will be admissible. We need to understand the nuances of a trial process, of the admissibility and relevancy of evidence. And to know more, we are here waiting for you at Ambition Law Institute. Thank you so much.